Hi there, my name is Naomi Metallic. I'm a lawyer and I'm also a law professor at Dalhousie University. And I'm going to do two videos on the Caring Society case. This first one is about the main decision, and then I'm going to have a second video that I'm going to upload that is particularly about the recent 2019 September compensation decision. And so my hope is that people will learn some things from this overview of the case, and I try to go into a little bit of detail just to help people understand it better. So let's get started. Okay, so this case goes back to really the main person who has been really fundamental in Canada in pushing First Nations child welfare out into the spotlight, and that is none other than Dr. Cindy Blackstock, who is a Gitxsan woman and a social worker. It all started for her when I think one of her first jobs was working as a social worker in a child welfare agency in the province of British Columbia for a while, and then at some point she moved to work in a First Nations child welfare agency in British Columbia, and right away she says that she noticed that there was really big differences and big inequalities between what she saw in the First Nations communities and the services that the agency was able to offer children and families versus what she was able to do when she worked with the province. So this really fueled her life's work as an advocate for First Nations child welfare issues. Over time, she would become and found the executive director and found the First Nations Caring Society, which is an agency that or a society that advocates for First Nations child welfare agencies and raising awareness on First Nations child welfare issues. Through her work with the Caring Society, she ended up bringing it to government's attention that there were problems, and together I think that they agreed to fund two reports. In fact, there was one in the late 1990s and then early 2000s. Two reports were written. And Cindy had hoped that these two reports would raise awareness in the government, and right away that they would see that there was inequalities and they would do something about it. She was really surprised to see that even though the report showed exactly what she thought, which was that there was profound differences and inequalities between the First Nations child welfare system and the provincial child welfare system, nothing was done by the government of Canada to really, or very little was done to really do anything different. Because of that, Cindy eventually decided to bring this issue to the Canadian Human Rights Tribunal. And to the so where you see CHRT, that's a reference to the Canadian Human Rights Tribunal. First it went to the Canadian Human Rights Commission, who decided that there was merit to the complaint, and eventually they decided to send it to the tribunal in 2007. There was a bunch of history of the case. Really, it was before the tribunal for 9 years before we got a final decision, and there's lots I could talk about there, but Canada tried to get the case thrown out before it got heard by the tribunal. It had to go all the way to the Federal Court of Appeal to make sure that it didn't get thrown out, that it was saved, and eventually we get to a final decision from the tribunal in January 2016, where the tribunal ruled that Canada had discriminated against First Nations children and families on reserve and also in the Yukon. Now, I just want to say that the situation in different parts of Canada fluctuates. So in the Yukon, most of the First Nations are self-governing, so there's not reserves per se anymore, but Canada does fund child welfare services in the Yukon. However, in the Northwest Territories, The situation is different. It's the territorial government that addresses child welfare issues. There are still issues with respect to Indigenous children, but it's not the exact same situation. So the case was not about the NWT or Nunavut for that, for the same reason, but rather the focus was on child welfare services on reserve and in the Yukon. Okay, and a couple other little introductory points. So Caring Society was the main complainant in the case, but so was the Assembly of First Nations, and later the Chiefs of Ontario and Anishinaabe Aski Nation. Both of those groups are from Ontario. They later became part of the case as well. So, but the main thing to know is that we got the ruling on the main case in January 2016. Canada did not appeal the decision. So I'm going to walk you through why the case came before the tribunal and what comes out of this case. I do a lot of work in human rights law, and I think that this is one of the most important cases to have come out for First Nations people to date. It does a lot, and I'll try to explain why I think it is really so important. What we call it in law is it's a watershed decision. It means it's a really important decision. Okay, so before I get into what the tribunal found, I want to help you understand the building blocks of why this even had to go before a human rights tribunal, okay? And it all has to do with how services are delivered in First Nations communities. I'm going to focus on child welfare because that's exactly what the Caring Society case was about. But I will preface my comments by saying that it's these same problems that I'm going to talk about before talking about the findings in the case are virtually the same, pretty much the same across the board when we're talking about all services. I would call them basic services or essential services. Those are sort of services that are designed to meet people's basic everyday needs. So in addition to child welfare, that could be social assistance, assisted living, housing, education, water, infrastructure, emergency services. What we see across the board is really a system that works very differently than how things work off reserve. And really this is part of a design of how the federal government runs things. Okay. So a lot of the things that I'm saying really apply to other areas. That's my point. And in fact, there's a bunch of other human rights complaints that are currently before the Canadian Human Rights Tribunal that are really similar to this case, alleging that there is chronic underfunding in services, and really it all comes back to how these services are designed. So yeah, just know that this is not the only issue. These are human rights issues really kind of across the board. Okay, but let's go back to child welfare. So my main point on this slide is that how child welfare works on reserve is really different than how it works in the province. So the way it works in the province, it's pretty much the province is a one-stop shop. And what I mean by that is that the provincial government has jurisdiction over child welfare, meaning it's the one that makes the laws over child welfare. It's the one that funds child welfare services. It passes laws and regulations and policies over child welfare, and also its employees, its public servants deliver the services. So like I say, it's all in one-stop shop. It's really different how it works on reserve, in that, you know, we've got actually really 3 jurisdictions at play, which makes it really complicated and confusing. So we've got the federal government who funds child welfare services on reserve and in the Yukon, and these are through some things called funding agreements. Then you have, well, what are the rules that apply on reserve? And what we're going to see is that the rules and standards that apply to child welfare services are provincial laws and policies. And sometimes you're going to see on the screen, you see CW, that's my acronym for child welfare. But generally, provincial rules are borrowed and applied to service delivery on reserve. And that happens across the board too. Okay, and then the third important thing to know, it wasn't always the case, but primarily starting in the 80s and 90s, because First Nations communities started to say, well, whoa, we don't want the federal government or provincial governments, their staff coming in and delivering services in our communities. We want to control that. We want self-government. What happened was not self-government, but the government did say, the federal government said, well, we can allow you to deliver these services. You still have to abide by, you have to follow the rules that we tell you to, and you have to, go jump through the hoops that we tell you to, and the agreements that you sign, but you can deliver the services. So that is how that works today. That we have First Nations governments, and sometimes you have bigger agencies like First Nations agencies, and we see this a lot in the child welfare system. So here, for example, in Nova Scotia, there is a Mi'kmaq Child and Family agency, and it represents all 13 communities and provides services to all 13 communities. So that's an example. So of service delivery. Okay, so kind of clear at this point. We've got 3 different things going on, and they're all done at different jurisdictions, which is complex and very different from the provinces. Okay, next. I'm going to talk a little bit about the history and try not to get too overly complex. If you're very interested in this, I do write articles, and I have a big long paper about this, so you can go find it. If you type my name in and put child welfare, you will come up with my writing on this. But I want to try to make this pretty simple. But so I will just say, so the question is, how did it come to be the complicated way that it is? I guess I'm going to try to boil down the answer to say that basically after World War II is the period that we start to see the kinds of services that we are now all used to, like child welfare, like social assistance, all sort of being developed, not just in First Nations, but across the board is what I'm talking about. In some circles, it's called a social safety net. We started recognizing that people need help sometime, and the government has a role to play in supporting people and helping them when they fall on hard times and these sorts of things. So that was one piece. So we have provinces primarily, but also the federal government starting to develop these programs. But it's noticed after World War II that not any of these programs are being offered in First Nations communities, so on reserve. And it's noticed that, so they're not getting the same level of help or anywhere near the same level of services as people off reserve in the provinces. So so people start to get concerned about this, and so there's, it's noticed that they don't have the same level of services. So the federal government appoints a committee to study services in First Nations communities and see what the issue is. And so, there's this realization that there's a lack of services for First Nations and that they're not being treated the same as other citizens. And the solution that was identified by the federal government committee at this time was informed by an idea of equality that is now considered outdated. So what we call formal equality. Today we recognize something called substantive equality, and I'll talk about it more after. But basically, formal equality is this idea of, you hear people say, I don't see color, or I'm color blind, right? I treat everyone exactly the same. But the problem with that is that often when somebody says that, they're really treating them from their own point of view and their perspective, and they judge them according to their values without recognizing that different people from different cultures and different experiences will have different ways of seeing things and different needs so that different needs that need to be recognized. So back in the day, when this committee says, okay, well, the First Nations don't have all these services, the idea was, well, the problem for First Nations is that they have this Indian Act, they have reserves, these things are holding them back. And really, the best thing for them would be to be treated like all other citizens in Canada and have the provinces take over services for them. And that will be the solution. not recognizing the long history of colonialism that already happened to this point, that had, resulted in First Nations being marginalized on reserve, residential schools not being able to participate in the economy, not being able to participate in their traditional activities. All those things were sort of glossed over, and the magic solution was for First Nations to basically assimilate into mainstream culture. And so with this idea, with respect to services, was the idea, well, let provinces take over services with respect to First Nations. So that was the ultimate solution that was identified to the federal government. So the federal government takes this and tries to run with it, so to try to force the provinces at first to take over services on reserve. And without getting too technical about the legal mechanics around this, basically, at first, the federal government tried to use a new section of the Indian Act to basically give control over to the provinces. However, Canada did that without consulting the provinces. And the problem here is that in giving, the provinces the ability to provide these services, what they were also imposing on the province was the requirement to pay for these services for First Nations on reserve. And most of the provinces didn't like that. They said, well, it's not our responsibility. First Nations issues is something that is covered under the Constitution Act 1867. It gives the federal government jurisdiction over lands reserved for Indians and lands reserved for Indians. And so, the provinces pushed back on this. They were extremely reluctant to extend their services. And so then the federal government kind of had to go back to the drawing board and then decided it was going to try to negotiate with the provinces for them to be able to take over services on reserve. And when it comes to child welfare services, basically what happened is that most provinces were willing to extend a limited amount of service on reserves to First Nations to step in if there was a case of abuse or neglect, but only if the federal government agreed to reimburse them pretty much 100%. Right, and in some cases, the limited services that were extended in some places were basically if the child was in desperate need of assistance, they would come and step in. But on the other hand, what also happened was that in some places, this was kind of used by social workers to step in at the slightest instance, right? To go in and take children from First Nations communities and place them in non-Indigenous homes. And so you see the years that this is happening is around the 1960s. And this is where we get the concept of the 60s scoop. That basically why it was called that is that in some places, social workers were now using their ability to go step in First Nations communities and using the slightest reason to go in and take children away from their families. So that's how it all got started with the provincial government coming into this role. But remember, it's all funded by the federal government. Okay. And then we get 1970s, 80s, and really more, especially in the 90s, the federal government implementing something called program devolution, which is when they give First Nations or First Nations agencies the ability to deliver the service. And to get technical, that's done through something called funding agreements. And these funding agreements are called contribution agreements. And I'm not going to get too detailed about it, but basically the thing about contribution agreements is that it gives most of the control to the federal government. The federal government determines how First Nations are to deliver these services, how much funding they're going to get, and they also require the First Nations to file all kinds of reports, and it's been criticized that there's too many reports really for First Nations that are imposed under these agreements. And under these agreements too, the federal government would require First Nations in delivering child welfare services to follow provincial laws with respect to child welfare. Okay. So that is a picture of how this came to be. And now I'm going to move to problems with how this whole system is designed, right? So one big problem is that really the whole, I mentioned earlier, the committee that suggested that, the solution to dealing with the problems that First Nations were seeing on reserves in the 50s and 60s, and that were seeing extreme poverty because they didn't have the same services, the idea of just, let the provinces come in and let them be absorbed into, the provincial societies, is really a concept of assimilation. Right? And it's the same concept that if you've ever studied any history around First Nations issues, you would have heard that in 1969, Pierre Trudeau's government back in the day in 1969 tried to pass something called the White Paper, which proposed to get rid of reserves in the Indian Act and treaties and just, have First Nations people be absorbed into, the mainstream. And at that time, there was such a negative reaction to it by First Nations people that eventually the government pulled back on that policy and said, no, we're not going to do that. So in 69, we see the government saying, no, we're not going to pursue that policy. But yet still, there's an early kernel or seed of that in how the government pursues service delivery in First Nations communities, because it seeks to try to get and apply provincial rules with respect to these services. So it is really at its core premised on this idea of assimilation. But not only is it premised on this idea of assimilation, it is assimilative, right? And this, I'm going to talk about that with the next couple of problems. The next one is that the way this whole system is structured, it really doesn't leave a lot of room for First Nations to have any say over the delivery of services in their communities. And even beyond that, it doesn't leave a lot of room for either the federal or the provincial government to come up with policies that make sense for First Nations people. So for the longest time, even though the province's laws were applying in First Nations communities, the provinces didn't go out and consult with First Nations about how child welfare would best work and best suit their needs. Usually the provinces said, well, First Nations issues is Canada's issues, so let Canada decide that. And Canada would say, well, we're applying provincial rules, so it's really a problem for the provinces. So we'd get this, and what would happen is that really there was nobody taking control and really saying, well, okay, it's my responsibility to come up with what is good rules and laws and policies that will best ensure that First Nations children, grow up to be healthy individuals. So nobody is looking at that kind of stuff. So that's another problem with this system. Okay, next. It's very much related to that last point, but because you have nobody who's really thinking about how to make these rules the best for First Nations people, it's really not a culturally appropriate system. The rules that are being applied come from the provincial system. The rules in the provincial system are often based in Euro-Canadian values. And that's just what I mean is the way of thinking of people who have descended from Europeans. And the European tradition tends to value making money. So that's capitalism. It also values the individualism, so focusing on the person. They also tend to see the family as a small unit, as a mom and dad and two kids. A lot of that is really different from how many First Nations think. So one example, a lot of First Nations are generally not too concerned really about just making money, right? Or capitalism, right? They're often kind of concerned about ensuring that the collective is protected and also protecting the earth, Mother Earth. You've also, the way that family works in First Nations communities is different too. You've got usually, big kinship networks. By that I mean it's not just mom and dad and two kids, aunties, uncles, grandparents. They're all involved in the family unit, and sometimes they all live together, in close proximity to each other. Various people have roles in raising the children, and so this is all very different. And so a system that is based in Euro-Canadian values are going to have things in it that really reflect their values and not First Nation values, and may not really appropriately accommodate or take into account First Nations needs. And so that's what we see. We see problems with that. We have rules in the child welfare system that really, are based on this idea that really it's just mom and dad who are in the picture and not a broader family unit. So there's not a lot of rights for that broader kinship network. Often Indigenous parenting practices are sort of looked down on as well as being permissive or something like that. Also, the provincial system, the values and the rules in the provincial system often don't take into account the realities also of current issues in the First Nations community. So, the chronic underfunding of not just child welfare, but a bunch of other services. So housing, and that there's a massive housing need in many communities. That's also not taken into account. And so an example I often draw on that shows that the rules are not thinking about those differences is, for example, if you want to be a foster parent, usually there are rules in the provincial system that say that a foster parent has to have one room in the house per child if they want to foster. But that is a really big challenge if you're in a First Nations community that is experiencing a housing shortage, and you may have more people than one person per room, really, just realistically, because of the housing shortage. So rules often don't take those things into account. So the rules are not culturally appropriate. Let's move on to another problem with this system. I talked about how there are these contribution agreements. That's basically the contracts that allow First Nations to be able to deliver the services, the child welfare services. I won't get too deep into this, but it is a problematic area. I mentioned earlier, generally these agreements, the federal government basically writes these agreements. There's not negotiation like in a real sense. It's the federal government will say, here's the contract, take it or leave it, and usually the First Nations take it because they don't really have much choice. If they want to have these services in their communities, they feel they have to accept these contracts. So there's an imbalance of power here. All the power rests with the federal government. There's very little flexibility in these agreements. There's really no self-government in this model. And as I said earlier, there's also, these agreements often require First Nations to fill out tons of reports and about delivering the service and how much money they're spending. And there has been, some monitoring of the federal government's practice of collecting all these reports, and it's been reported that, they do collect too many. In some cases, they were collecting 160 per year, and also that they're not doing anything very productive with these reports. Yes, they're keeping track of how much money is spent, but they're not actually looking at, is it actually achieving good goals? Is it helping people? Is it improving their well-being? Is it moving them towards self-government? It's not looking at any of that stuff. So these are all very big problems. Okay, let's move on to another problem with this system. This is again getting a little technical, and I apologize, but it is a bit of a big deal for me as a lawyer and somebody who believes in the rule of law. But I think the whole way that this system is structured, it does violate the rule of law. And what I mean by that is that, we have laws in place so that people know what rules they're supposed to follow. They know that these rules are also going to be, that the governments are also going to be held to these rules. And that if somebody breaks those rules, that they can go and get the dispute heard before an independent and impartial decision maker, and that so they can get justice. A lot of this is all having to do with justice. But the way that so sometimes having a system that actually sets out clear rules is really helpful, because you can hold decision makers like the federal government accountable for their actions. And the problem with how this whole system is sort of created is that there's not a lot of written laws in place, and it makes it really difficult to actually hold the federal government accountable. And so it's been noted by the Auditor General, who is government sort of watchdog that looks at whether the government is fulfilling its duties properly. The Auditor General has said it's a problem that there is actually no federal law in place on this. Like, there's nothing in the Indian Act on any of this stuff, or any other law. And the fact that there's no law makes it hard to say what is government actually supposed to be doing. And the government always says that it doesn't have to do much, or it doesn't have to do it doesn't have to meet human rights standards. That's what it argued in this case, and that it just funds. It doesn't have any other obligations. It doesn't have an obligation to fund at a certain level. So these are the sort of things that happen when you don't have these things well set out in law, and you can point to them and you could take the government to court to say, see, they didn't meet what it said right here they have to do. So this is a challenge. And when you don't have that, it leaves a lot of room for the government to do basically what it wants. It could change the rules, and or it could focus more on one thing. It could focus more on just making sure that all the money it spends is all accounted for, instead of maybe caring about something like whether more children are being taken into care than need to be, or that children are being discriminated against. Also, the system, the way it's structured, until the Caring Society case, there was really no case like it that had been able to successfully bring the government to court on this. And also because of the way the system is structured, often courts don't even know how to start looking at this issue. They can't look to a law to say, oh, they're violating the law right here, this section right here. And so they can't really... Courts have had a really hard time even understanding this area. So that has made it really hard to challenge. And I would say it has allowed discrimination to happen for a long period of time because of that. So those are a few of my comments on the rule of law, that it's a problem because it has allowed Canada, I think, to get away with significant neglect of First Nations issues, which has included the discrimination that we find in this case. Okay, I'm going to move on from that. But this is really building on that last point. I think the way this whole system has been built has allowed for chronic, known underfunding of these services, which is a huge problem. So one of the big statistics that Cindy was coming in with, based on the 2 reports that she had written before, was they were able to measure how much less services for child welfare was getting compared to in the provincial stream. And the approximate number was somewhere between 22% to 37% less. Although the government says that what it's it was saying what it tries to do with respect to child welfare on reserve is provide similar services and similar funding as in the provinces, it actually never really tracked that. So it said it was doing that, but it didn't really know. And again, that the Auditor General, who is a watchdog of the government, has actually said back, I think in 2004, to the federal government, you don't know, and you should know, and you should go study this, and you should, keep data on this. And yet the government didn't do anything. And so that came back to bite the government later in this case. That was one of the things that the tribunal looked at and said, the Auditor General told you that you weren't actually providing comparable services to the provinces, and you didn't go study it, and you didn't do anything about it. There was also internal reports, and these came up in the case. There was a lot of evidence in the case that showed that, not only was this going on, but the Department of, back then it was Indigenous Services or Aboriginal Affairs. Now it's Indigenous Services. Anyway, whatever you want to call it, we're going to call it INAC for this PowerPoint. INAC staff knew that it was underfunding this service, at least for a decade. And the reports that Cindy had produced and given to them showed that. And so there's, a quote from a report that was actually produced by INAC that was in the case from 2006. And in it, the government employees say, if current social programs were administered by the provinces, this would result in significant increases in costs for INAC. What that means is that, if we were providing the same level of services even as the provinces were, we'd be paying a lot more money, i.e. they were not paying a lot. They're paying much less than the provinces. So there was a recognition here that they were underfunding. It was known. And the tribunal comments on this in the case, and we'll come back to this, that, INAC was not even providing anywhere close to what even the level at the provincial level was. Okay. And And I'll just say a few things. This is a related point. So what the case really, when you go read it, a lot of the focus is on those particular funding models that existed, and I don't think it's necessary to dive deep into that with you. I think the thing to know is that there were a couple of different funding models for child welfare services on reserve. And the main point to take away is that they were flawed. All of them were flawed. They generally did not fund, well, one of them didn't fund at all any type of prevention services, right? All the money was put into apprehension services, and so there was no money to help parents, First Nations parents who may have been experiencing difficulty, but maybe not at the level where they needed apprehension services to come in. Had they had services, everything might have worked out fine. But no, there was no money for prevention services, and so you get apprehension instead. One did have prevention services, a little bit of funding, and another one of the models, but at the same time, all the other services were so underfunded that generally agencies couldn't even use that money for prevention services. So it was a mess. Lots of other things were underfunded in these agreements. Staff were not paid anywhere near the same amount as, social workers working for the provinces. There's a lot of problems. So the tribunal found that all of the agreements underfunded prevention services. They didn't ensure culturally appropriate services. And basically at the end of the day, because they underfunded some key services, basically created an incentive for children to be removed from their home as a first resort rather than as a last resort, which is what it should be, and which it is or should be within the provinces as well. So big problems with that. And so that was one of the key findings from the decision. And because the whole system, as the tribunal found, results in children being apprehended as a first resort as opposed to a last resort, this gets tied, obviously, to the significant overrepresentation of First Nations children in care. And so, I think the statistic that's quoted within the decision, and I hear Cindy mention often, is that, at the time of the case, there was 3 times the amount of children in care than there were children in residential schools at the time that those schools were, at their height, meaning when there was the most schools running at one time. And so on the slide here, you can look at some of the statistics here. So earlier I mentioned the 60 scoop, and I pulled out some numbers that I had found from 1977 that showed here the 60 scoop was already operating, right? And so you look at some statistics of the First Nations children or Indigenous children in care back in 1977. So, for example, AB is Alberta, 44% of kids in care were First Nations. Saskatchewan, 51%. Manitoba, 60%. So that's the 60 scoop, but let's jump to some stats that I had found for July 2015. And they're actually even higher in all 3 of the provinces that I just mentioned. And in every single province, you see that First Nations children are overrepresented, or well over what the actual average, or what they represent of children overall in the within the province. So British Columbia 55%, Alberta as opposed to 77, we go from 44 to 69, Saskatchewan 51 to 65%, Manitoba 60 to 87%. And even in provinces like Ontario, Quebec, and New Brunswick, in the rest of the Atlantic provinces, still, well over what the First Nations children actually represent, the population. And the numbers in the territories are significantly high as well. So this whole system has resulted in overrepresentation. And I'll come back to that, but that is a clear finding of the tribunal in this case. Okay, so that was a little picture of problems of this system. And the decision in Caring Society is really, important. As I said before, it's a watershed decision because it finds things that no other court or tribunal had, and which are important findings which I argue help us address those problems, a lot of those problems that we just focused on. So one important finding, really important, is that the tribunal found that Canada is responsible under human rights law to First Nations children with respect to child welfare services. Going into this case, Canada argued that it wasn't. That all it did was fund child welfare services. It doesn't, it's provincial laws that apply, so it's a provincial responsibility. So Canada tried to argue that it wasn't responsible for the ensuring these services weren't discriminatory. And the tribunal did not buy it. Very clearly, the tribunal looks at the history of child welfare and says, it's not true that you're just a funder. You ultimately, Canada, at the end of the day, make the decisions that determine, what's going to happen in First Nations child welfare. And you do that under your power in the Constitution, Section 9124. So they found that Canada exercises significant control and power over child welfare services. And just because Canada decides that it's going to have agreements with the provinces, as it had before, or now with First Nations, and in that it uses provincial rules, that's a choice that Canada makes. It doesn't mean that the provinces have the main control. So really important finding, because we see the similar arguments across the board when it comes to Canada, trying to say we're not responsible. They are responsible according to the tribunal. And this wasn't appealed by Canada either. Even beyond that too, the tribunal doesn't have to make this finding in order to it didn't have to make this finding in order for the case to be decided, but the tribunal does touch on Canada's fiduciary obligations to act in the best interests of First Nations children, and so it suggests that INAC and Canada do have a fiduciary obligation with respect to First Nations children. And beyond that, they also said that one of the reasons why they have a fiduciary obligation is because the decisions that they are making, that Canada is making with respect to child welfare on reserve, affect the right to language and culture of Aboriginal children. And that's really important. This is a Section 35 protected right. And so that's what was one thing that really reinforces that there is a strong fiduciary obligation. So those are all good findings. Those are strong findings that Canada has some really important responsibilities here. Okay, so that's a big key finding. Next big key finding from the case is Jordan's principle, and that it is an important remedy to this problem. I call it interjurisdictional neglect, but my easier way that I sometimes explain it is the game of hot potato that the provinces and the federal government continuously play when it comes to any First Nations issues. They treat First Nations issues like it's a hot potato. Oh, it's not my responsibility, they're your responsibility. No, they're your responsibility. And it happens over and over and over again. And in the process, Indigenous children and adults and communities are harmed by them failing to do what they're supposed to do and meet their obligations. So a real important finding is Jordan's principle from this case. Now, Jordan's principle comes from Jordan Anderson, who was a young First Nations man who was born with significant disabilities. He required medical attention from the time that he was born. It was clear that he was not going to live a very long life, but at some point it was clear that he could go live out the rest of his days with his family outside of hospital back in his community. The problem is that he needed certain services in order to do that. And the federal government and the provincial government argued about who had to pay for it. No, we don't have to pay for it. It's your responsibility. No, it's your responsibility. Again, the hot potato. And what happened is that poor Jordan died because in that period, without ever having to being able to set foot in his home community and be with his family, because all that time was spent between the federal government and the provincial government arguing. And so what happened after that is in 2007, the government of Canada, Parliament, passed a resolution that was supported unanimously, and it was named after Jordan. And the principle is a child's first principle. And basically what it says is that when there are children, when there's disputes between governments, and that could be the federal government and the provincial government, or it could even be between, departments of the same government, so Health Canada and INAC, if there's a dispute between them over who is responsible to pay for a service to a First Nations child, that dispute shouldn't hold up the child receiving the service. So the child first principle is whichever government was contacted first by the child or by the child's community to provide the service, they should pay the service. And then they can turn around and they can duke it out with the other government about who should really ultimately pay, and they can figure out who's paying what. But it shouldn't impact on the poor child who needs the service. So that's the child's first principle. And that's Jordan's principle. And Canada agreed to follow that in 2007. But one of the key things that was found in the Caring Society case is that even though Canada agreed to it, in the way that it was delivering child welfare services and providing services to First Nations children, it was not respecting Jordan's principle. It was really only following a very limited, narrow understanding of what Jordan's principle is. They limited it to children having multiple disabilities and and only with respect to health services. So they weren't using it to provide perhaps services that a child might need in the child welfare context or with respect to any other services. So the tribunal found that Canada's and Health Canada's approach to Jordan's principle since 2007 was narrow. It was too narrow, that it was not living up to what it had promised, and basically found that Jordan's principle mandates coordination between the various government programs designed to support the well-being of First Nations children and families, and it's intended to provide them with adequate and culturally appropriate services, and that's what the government should be trying to do. So that's another really important finding from the case, is that the government has to comply with a broad understanding of Jordan's principle, so that that dispute, that hot potato game between the provincial and federal government that always happens doesn't impact and harm First Nations children and families. Okay. Next big finding from the decision. And this goes back to the stuff we discussed earlier about how assimilative the program is, how it's not culturally appropriate. So one of the things that the tribunal finds in the case, and this is kind of based on the historical record, is that around the time when the federal government decided it wanted to start phasing out residential schools, which is around the 1960s, although the last one only closed in 1996, is around the same time that child welfare services through the agreements between the federal government and the province started amping up. And so this is when we get the 60s scoop. So you get basically, and the tribunal finds this, the child welfare system becoming the new residential schools, right? So it basically replaces it. And it's based on similar assimilative assumptions and including that First Nations parents are somehow unfit to take care of their children. Beyond that, too, they said not only did it replace the residential schools, but the way that it's structured and the way that child welfare operates, it is providing incentives for taking more kids out of their communities as a first resort rather than a last resort. So we talked about that earlier, about how the the funding agreements are structured such that there's not enough services, so that all the agencies end up doing is apprehending kids, or often that would happen. Beyond that, too, they found that, often kids are removed from their families. They're not placed in situations that are back in the community or with relatives, but often they're placed in non-Indigenous homes, right? And so through that, often they stand very vulnerable to lose their language and their culture. And so that also was something that the tribunal compared the current day child welfare system to the previous residential school system, because both results in First Nations people losing language and culture. And even in sort of a bigger, broad sense, the last point here, the tribunal found that really, at the end of the day, similar to the residential school era, today the fate and future of many First Nations children is still being determined by the government, and here they meant the federal government. And so really it's a statement about how much control the federal government is continuing to exert over the lives of First Nations people, and in a way that is really quite harmful, just like in residential schools. So the message here is that if the child welfare system perpetuates the same sort of historic disadvantage as Aboriginal people experienced in the past in residential schools, then it is discriminatory. And the tribunal builds on this next. So one of its last key findings here is that the services that First Nations people are entitled to is informed by substantive equality. Remember, I mentioned this principle earlier, but that is our modern concept of substantive equality, not formal equality, not I'm colorblind and I treat everybody equal, but substantive equality is recognizing that people have differences. Those differences are important, and those differences need to be accommodated. And so, what the tribunal found here was that substantive equality with respect to services means that First Nations people are entitled to services. And so I'm reading from the first bullet here. The tribunal found that First Nations are entitled, pursuant to domestic and international human rights law, services that meet their distinct needs and circumstances, including their cultural, historical, geographical needs and circumstances. So let me try to back this up a little bit. So a lot of times people heard about this case in the media after it was decided, and what most people think this case means is that Canada was underfunding child welfare services on reserve, and that the tribunal ordered that was discriminatory. And so people take that to sort of understand that, all right, they were underfunded, and here's where the provinces are, so the federal government has to offer at least that. That is not what this case stands for. This case stands for that at the very least this is what the federal government has to provide, not below this, at least here. But actually what the tribunal says is it's not about just receiving similar services to the provincial government. In fact, they suggest that just receiving the exact same services of the province may be discriminatory itself. They say it is discriminatory to use that as the only standard. Because, again, this goes back to, the worldviews that inform different systems, maybe based on different understandings of the world, different cultures, and different lived experiences. And to just say that First Nations should get the exact same as the provinces isn't enough, because they might have circumstances and needs, including the effects from residential schools and other colonial policies that make them need more services, perhaps, right? Or that the fact that they live in a geographically remote area, they might need more services. So the tribunal says that substantive equality means that they may be entitled to something different than just what the provinces provide, and more, right? Because of their distinct needs. So based on that, the tribunal found that Canada's approach to simply saying we're going to fund at the same level of the provinces and we're going to apply provincial rules and standards, that's not enough. That does not meet substantive equality. Yes, you can look at what the provinces do to get a sense of what is maybe a base level, but then you actually have to ask, what are the needs, what are the circumstances, and are the services meeting those needs and circumstances? So that's an extremely important finding from this case. And I've even gone on to argue in my papers that really what that finding means is not only that the First Nations are entitled to services that meet their needs and circumstances. Sometimes the only way to ensure that a service is going to do that is to ensure that First Nations design those services, right? If you have an outside government designing services, how are they going to know what the needs and circumstances are? Really, it's only, First Nations governments who really know what the needs are. So there's a sort of underlying equality or a self-government stream under this too that really ties together with the equality analysis. Anyway, I'm geeking out on law stuff, but anyway, it's a really important decision, and this particular finding on substantive equality is really super important. Okay, so this is my second to last slide. So what did the tribunal, after finding all those things, order in this case? So here, my first bullet is a quote that really speaks to what the tribunal thought overall of Canada's arguments in the case. And this is pretty, it must have been stinging to the government because it really reads that way. So the tribunal said, overall, the panel finds, so ANSI's, but INAC, or Canada's position unreasonable, unconvincing, and not supported by the preponderance of evidence in this case. So Canada was really not convincing in its arguments that it had no funding obligation and it wasn't discriminating and it tried to do all the best that it could. That really fell flat before the tribunal, given all the evidence that had been before it. So based on that, and because this was such a big case, the first thing the tribunal said was INAC has to stop its discriminatory practices and reform the First Nations Child and Family Services programs. Right? And even in the decision, reform is written in all caps and underlined. So it's pretty clear the tribunal really felt that it was massive reforms that needed to happen. They also said that INAC must stop immediately applying a narrow definition of Jordan's principle. And then there are several other things that were requested in the case, including compensation and other remedies. But because of the magnitude of the case and how important it was, the tribunal said, I'm not going to just decide that right now. I have some questions. I want to get the parties back before me and hear a bit more, and we'll decide that issue later. So they said, we're going to put that aside for now, but the parties will come back soon and we'll talk about this more. And so we're going to keep jurisdiction. Basically they're going to continue to hear things related to the case. Usually once the tribunal makes an order, it's done, it's over, and they don't hear anything more on it. But here the tribunal said, we're going to continue to hold supervisory jurisdiction to make sure that the really important orders that we're making get followed through on. And that is really important, and we're going to see why in a minute. Well, here, I'll show you why. Because there's been, and I won't go too deeply into all of this, a ton of decisions after the 2016 decision that I just covered with you, where Caring Society and the AFN had to go back to the tribunal to say, look, Canada and INAC, they're not following the order that you made, to follow Jordan's principle and to immediately reform the First Nations Child and Family Services program. So you see there's seven decisions here, and most of them are about the failure of Canada to really follow the spirit of Jordan's principle as defined by the tribunal in the case. So this kind of went to Canada's really seriousness about really continuing to really follow the decision. There's one of the cases, I believe, the number 3, I think, where, no, it's a later one, but there's one of the decisions where the tribunal actually says something like, our decision was not optional. It's a mandatory decision of the Canadian Human Rights Tribunal, and you have to follow it. So yeah, there's been big challenges up to this point. Even though Canada said it was going to comply and said that it was not going to appeal the decision, yet we still see 7 more times after that. And there was a couple other decisions in there too, where the tribunal had to say, you have to follow Jordan's principle and you have to do these other things and you have to give us more information in order to comply with the order. So I'm going to leave it there. I'm going to sign off on this one. And if you want to know more about what comes after these 7 decisions, we get the order from September 2019, watch my next video on the compensation order. Thank you.